Good afternoon, everyone. My name is Nicole Sanders. I am the Industry Education Manager here at the ILCC. Thank you all for joining us. Today, we have a webinar on the appeals process. Our host today will be Richard Hayward with the legal team here at the ILCC, and our moderator will be Jackie Villa. We're going to go ahead and get started. Sorry for the late start. And we'll go ahead with the presentation. After the presentation, there will be a Q&A section. The process for this is you all will submit your questions in the chat. Jackie will read them off, and Rich will respond to your questions. Please keep your questions specific to the appeals process. Anything outside of the appeals process, we will direct you to the legal inbox, and you can submit your questions there so that someone from our legal team can respond to you in a timely fashion. With that being said, we will go ahead and get started with the presentation. Jackie, thank you for joining us today and doing this.
Okay, Nicole, thank you. I apologize for the delay today. It's related to technology. Technology is great until it's not. So we appreciate your patience. Also, it's interesting for me, I'm talking to an empty room. I'm not used to talking to empty rooms. It's very difficult to know if anyone is listening or understanding anything I'm saying. It's similar to talking to my own kids. So I guess I should be used to that. As Nicole said, my name is Rick Haymaker. I am legal counsel for the Illinois Liquor Control Commission. Together with Jacqueline Villa, we manage the liquor license appeal process, or the local liquor license appeal process. And I want to be clear to everybody out there what this webinar is about, so that you don't get through half of the presentation and trying to figure out what is he talking about. So very specifically, this is about how the local liquor license appeal process works. The Liquor Control Commission, the State Liquor Control Commission, from where I'm speaking, is an appellate body for local liquor license decisions. So that's what we're going to hone in on today. It's not related to the appeals process, say, for state commission decisions. We're really restricting our presentation to the local appeals process. So with that, I'd like to direct you to some very simple objectives, what we want to accomplish today in the webinar. And that is a little bit of background into the Illinois Liquor Control Commission, because I did take a look at those who have signed up, and some may have a base amount of knowledge about how the Liquor Control Commission operates, and some may not. So I'm going to assume that everybody doesn't really know, have a base amount of knowledge of how alcoholic beverages are regulated in Illinois. So we'll start with some background. We'll then transfer into more of a nuts and bolts presentation about how the local appeals process works, which we'll be able to follow along on some slides that have been prepared. And then if any of you have any questions, you can feel free to enter them into the chat box, and we'll do our best to answer them. So with that, let's start with the role and the structure of the state commission, or the Illinois Liquor Control Commission, or the ILCC. Anytime I use any of those terms, I'm talking about the state agency that is authorized to regulate alcoholic beverages in Illinois. It's an independent agency. It's made up of 7 commissioners that are appointed by the governor and approved by the Illinois Senate, and they're all appointed for 6-year terms. In addition, there is an administrative structure to the agency, and that the administration, the head administrator is the executive director. The executive director also is appointed by the governor and approved by the Senate for a 4-year term. There are many divisions within the State Commission. The divisions that you may have interacted with include the licensing division, responsible for licensing, as the name would suggest, the enforcement division, the industry education division that's presenting this webinar, and the legal division through which I report. At our core, we are an alcohol beverage regulatory agency. That's really what our mission is, and is what the law, the Liquor Control Act, directs us to do. We are an alcohol beverage regulatory agency. We have exclusive jurisdiction over certain types of licenses. So manufacturers' licenses, for instance, your brewers, your distributors, your distillers, winemakers. We have essentially within our state exclusive jurisdiction. Retail licenses, we also regulate. However, in that capacity, we share regulatory responsibilities with local commissions. Local commissions, as the name suggests, are alcohol beverage regulators from each and every municipality in the state of Illinois and unincorporated county. So if there is a liquor license, for instance, in an unincorporated part of the state, then the county regulates retail licensing within that area. So we're talking about, from my count, 1,294 cities, villages, or towns, and 102 counties that potentially can regulate retail liquor licensing in Illinois. That's close to 1,400 local jurisdictions, or at least potential local jurisdictions that could regulate retail sales of alcohol. And when I say the retail sales of alcohol, I'm talking about taverns, bars, restaurants, special events, grocery stores, liquor stores, convenience stores, any entity out there, any business out there that may sell alcohol to the public that most people are familiar with. Shared jurisdiction doesn't mean identical jurisdiction. There is some overlap with what we do as regulators at the state and with the local commissions. But one of the basic rules, it comes down to the following, is that the local jurisdiction can pass more restrictive laws and enforce more restrictive laws than the state. So for example, if there's a state law that prohibits any person under the age of 18 from being a wait staff, or a waitress, or a waiter at a restaurant and handling alcoholic liquor. The state rule is nobody under the age of 18. However, many municipalities increase that age to the age of 19, 20, or even 21. So there's an example of how a local jurisdiction can be more restrictive than the overall state jurisdiction. The other thing about this, it's relatively unique across the country. You don't see too many states regulating alcohol in this way. In many states, it's very state focused. The state is the primary driver and the locals are secondary. With in Illinois, it's more of a partnership, which makes the appeals process pretty interesting. Because while we are both regulators of alcoholic beverages in the state, in the appeals process, we kind of wear a different hat. We oversee the decisions of the local commission to ensure that the local commission has followed all the necessary laws and regulations in relation to their role as regulators. So on one side, we regulate alcohol in our own capacity, but in this case, in what we're talking about today, is overseeing what the local commissions have done and have they done it appropriately. Our authority to do this comes from, of course, the Illinois Liquor Control Act. And in the Illinois Liquor Control Act, there's a section, it's from section 7-9 of the Liquor Control Act. And it states that our commission, the state commission, has the authority to review any order or action of a local liquor control commissioner or a local liquor control commission. And when I use that term, local liquor control commission, that is the title given to the primary regulator within each community. And the local liquor control commissioner in every community is either the mayor or the village president or the county board president. They are the primary regulators of alcohol in each community and are given the title local liquor control commissioner. The act, again, any order or action of that person or that commission to deny a license, to revoke, to suspend, to fine a license can be appealed to the state commission. Interestingly, the refusal of the local liquor control commission to issue a license, the refusal to revoke a license, to suspend, fine a license, or even renew a license can also be appealed. All appeals have to be filed with our agency within 20 days of that order or action of the local liquor control commission. Now, nearly all appeals that I have been familiar with have been by license holders or license applicants. License holders who've been revoked, fined, or suspended, license applicants who've been denied. The reason I say nearly all is that since I've been doing this really since 2008, there has been one time where we received an appeal from an interested party appealing the issuance of a liquor license. And it was related to the issue whether or not the local liquor control commissioner issued a license too close to a daycare center. And of course, the daycare center filed an appeal. And as it turns out, both the commission and the subsequent court rulings were that the license could be issued within 100 feet of a daycare center. Okay, I'm told that we need to move on to pass the introduction to the PowerPoint. So we're going to turn to that to get you the nuts and bolts part of this presentation. If I could get there. All right, so this is going to take you kind of give you an A to Z of how to file an appeal and also what happens during the appeal process. Now, what we're going to try to do is make sure this presentation is posted online, so you all have more time to examine the details of this presentation and review it yourself. But I'm going to point out some key parts to each of these slides that may be of interest. First, in filing an appeal, I highly recommend that when you're filing an appeal, to find a lawyer to assist you to do it. I'm not a big proponent of having a lawyer assist you in everything that's done before the commission, but filing an appeal is a very legally driven process, and usually the assistance of an appeal does increase your chances of success. As I've said, the appeal has to be filed within 20 days of the order or action of the local commissioner. We have updated our processes significantly over the past few years. We will receive an emailed copy of your notice of appeal and deem that to have been filed if that is emailed. We ask you, when you do that, if you do that, please notify the local commissioner or the local commissioner's representative so that they know an appeal has been filed. If I can go to the next slide, Jackie. We're again. We typically work off of fillable PDF forms. So our website has been updated to provide notices of appeal, where you can enter in a fillable PDF as to the factual and legal basis for that appeal, to help facilitate filing an appeal, and then all the other documents that go along with filing an appeal. So we have very little paper to deal with these days, which is really a dramatic improvement, because appeals in the past were very paper intensive, and we barely deal with any now. Next slide. When we receive the appeal, we will send out an acceptance letter, and the acceptance letter will give you an idea of where we're going with the case, what documents are going to be required to be filed, and most importantly, it informs all parties that an appeal has been formally filed. And the reason that's important is related to the next slide. The next slide, this slide, is something called an automatic stay. This is not an order of our commission. An automatic stay happens by operation of law. So what I mean by that is, if, for instance, a local commissioner revokes a license and the license holder decides to file an appeal with our commission, as soon as we receive the appeal, by operation of law, that business is allowed to remain open and sell alcohol while the appeal is pending. And the acceptance letter informs everyone that, yes, we have received an appeal and we are operating under this automatic stay provision. One exception to that, and that is if the revocation or if the appeal we receive tells us that it's the second revocation or second suspension that has occurred within a 12-month period. If it's the second one within that period of time, then there is no stay that applies. And in those situations, we do our best to expedite the appeal to the extent that we can. Next slide, if we could. Status call is the first stage in the appeals process. Very simple. We have one on Friday, for instance, where we invite any of the pending appeal parties, mostly attorneys, to appear on a conference call to let us know where we're at with each case. Where are we at with the document submissions? Is there an attempt to settle the case? Any matters related to the appeal are attempted to be dealt with before we get to the actual hearing, which will occur later. And again, all status calls are done through remote, through a WebEx conference. Next slide. The initial filings, we ask all the attorneys involved to please don't make us send out certified mail. And again, as we try to update things, we want there to be a waiver of in-person service of all the documents so that we can interact through the cyber world instead of wasting time and money on certified mailings. It's worked very well over the past few years, and we don't see a reason why it needs to change. But we do need documents saying that, yes, we do waive the in-person service. Next slide. We will monitor the file while the appeal is pending before we get to the hearing. Again, we have to make sure that all of the record, the exhibits, sometimes videos, photographs, things like that, that the commissioners need to review, that we receive them before the actual hearing date. Let me just divert quickly. This is a moment to talk about the differences between the two types of appeals that we hear. We hear what we call an on-the-record appeal, and we hear a de novo appeal. Most of our appeals are on-the-record appeals. And it really is, I'll try to narrow it down to this, is that in an on-the-record appeal, the commissioner is just reviewing the evidence that was already presented at a local hearing to determine if the evidence was sufficient enough to support the action of the local commissioner. Okay, it's a very simple process. The hearing is much shorter. With the de novo appeal, we have to have an entirely new evidentiary hearing. So an evidentiary hearing is held at the local level, and if we do a de novo review, then we have to have a whole nother evidentiary hearing. And obviously that's going to require more resources, more time, more energy, and more cost to both the licensee and the local commission. The reason why we hold either one of those is the local commissions. Again, each municipality has the opportunity to pass an ordinance to say that the review of all of their decisions will be on the record. So if they have one of those on the record review ordinances, we'll review it on the record. If they don't, we have to do a de novo review. So a thing for the local commissions to note. One more thing on the submission, the monitoring the file and submission of documents. The local commission hearing should, there should be preparing a transcript prepared by a certified court reporter, and that the municipality may, and in many cases does, require the licensee to pay for the preparation of that transcript. Next slide. Notice of hearing. It's a pretty basic document. Once we're ready to have a hearing, typically we have one hearing a month or one hearing day per month. we'll send out a notice that will be for, if it's an on the record hearing, it'll be through a WebEx conference call, similar to our status calls. If it's a de novo hearing, then it still might be a WebEx conference call where we actually take evidence and testimony through the conference, to the video conference, or we have an in-person hearing in this room, and who knows, it could go on for days. We don't know. So the type of hearing and the type of notice you receive will depend on whether it's an on the record or a de novo. Next slide. We have you or the attorneys involved to prepare what's called a pre-hearing memorandum. It is effectively a way for the licensee and the local commission to summarize their legal arguments before the commissioners. And it's their best shot in writing to help narrow in on the important facets of the case. This is for the attorneys out there. This is not a briefing schedule type of situation. We want pre-hearing memoranda, if you choose to submit one, to be submitted concurrently with each other, with the local commissioner and the licensee, at least no later than 2 weeks before the actual hearing. Next slide. Here you go. I mean, on the hearing date, again, I'll summarize on the records. I mean, we're talking for an on the record hearing. It will include typically two of the commissioners who will preside over that hearing, and one case could last less than an hour because it's effectively just oral arguments based on to what extent the local commission properly ruled. If it's a de novo, it's a little more complicated. It could last maybe a couple hours, or again, it could last multiple days. Next slide. The decision, while Jackie and I manage the process, the decision is entirely made by the commissioners. Like I said, the two commissioners preside over the hearing. We will take the record of the case and it will be shared with all of the other 7 commissioners for them to deliberate on the matter at their next monthly meeting. And that is done in executive session, in closed session. And there is no further need for a presentation by the licensee or by the local commission. The commissioners are very good about reviewing and deliberating over every facet of the case. And I can tell you the group of commissioners that are engaged in the process now take it very seriously and are very very deliberate. They do not prejudge. Very deliberate about the process to try to come to the best decision for all sides. One thing to note: we do typically affirm local liquor control commission decisions more than we would reverse local liquor control commission decisions, but that's because that is what's required by law, is to affirm a local liquor control commission decision if there is no abuse in discretion. So some of the commissioners may not necessarily agree, or they would not have ruled in the same way, but unless there's a demonstration that the local commissioner abused their discretion, which is a different standard, they're not going to reverse the local commission's decision, and rightfully so, they shouldn't. Next slide. once the commission makes their decision, they'll tell the legal division staff to draft up an order. And we have many of those orders on our website. You can take a look at those if you want an example of what they look like. The thing to note there is that that might take some time. The timeline or the deadline to file an appeal to that to the decision, if you're the unsuccessful party, is 20 days from the date that we send out the order, and not the date that the commissioners make the decision, because the date we send out the order will be later than the date the commission sends out, makes the decision. Next slide. So the appellate process from the commission's orders begins with something called a petition for rehearing. And that's what I was referring to before. The unsuccessful party, if they intend to appeal the decision of the commission, must first file what's called a petition for rehearing. It's essentially a second appeal. Hey, there's something that you may have missed, I want to point your attention to, that kind of thing. That filing must be made within 20 days of the date of the decision. Next slide. And if then the commission denies the petition for rehearing, the unsuccessful party may appeal the decision up the chain, the legal chain, through the circuit court system of Illinois. So the first stop along that path is the circuit court, typically in the county in which the liquor license is located. So that appeal has to be filed within 35 days after the denial of the petition for rehearing. And then should that party then be unsuccessful at that stage, it would go up to the appellate court from there, and who knows, maybe the Supreme Court from there. I wish I could tell you the process for what happens if the commission grants a petition for rehearing. I've yet to see that, but I guess we'll cross that bridge when we come to it. I think that's it. I think we're ready for questions, if anyone has any.
We did receive one question. The question is, must the written decision by the local liquor control commissioner to deny a license application contain language of the applicant's right to appeal? It seems 20 days is a tight deadline to appeal and easy to miss.
It's a good question. I'm gonna answer that by saying I absolutely recommend that that language is in there. The more transparent that we can make the licensees' due process rights, the better it's going to be for everyone, for the local commissioner's argument down the line. You don't want to get hung up on a procedural technicality when you have a really good substantive basis for a denial. We do see that from time to time, and it's unfortunate at times if, for instance, a local commissioner doesn't give the required notice rights for a hearing. Let's say the notice rights, if you're going to revoke a license, is 3 days. You have to give a 3-day notice requirement before having a hearing to revoke a license. Well, if that's only 1 day or 2 days, or they didn't give any notice, they could have a really good reason to revoke a license, but they get hung up on a technical error. So I highly recommend that the appellate rights are put into any notice related to an application denial.
We don't have any further questions.
Okay then. Nicole, anything you'd like to add before we sign off?
We did get one more.
Oh,
The
okay.
question is, what should we do if we received a violation notice? No one came to the store, they just wrote us up based on vendor's invoice.
Well, typically, if there's going to be any action, whether it's by the state commission or the local commission, taken against the license, there should be a notice that goes along with it, a written notice, or at least some sort of communication sent to say that, you've received a violation. If not, it would violate certain due process rights. How is somebody supposed to have the opportunity to contest a notice unless you've received it either in the mail or personally served with that notice, or even, I suppose, through some sort of email notification, something like that. So my suggestion would be, if you're concerned about that, to reach out to whether it's the local commission that may have that you may be interested in, or if it's us, if it's the state commission, please reach out and ask if there's any pending violations against your license.
We haven't had any questions. Maybe we can give it a little bit of time to see if anyone wants to write a last minute question. But as of
Okay.
right now, we don't have any.
Okay. The other thing, Jackie, anybody that may have a question is always welcome to reach out to us, to the legal division here at ILCC .legal@illinois.gov, and we'll be happy to answer any questions people come up with along the way. There you see it. All right, then. Well, I think it's time to sign off. Again, please submit any subsequent questions. If you have any questions related to this presentation, we will try to get it up for you on the website. There's a lot of interesting information on the website. If you search on appeals, for instance, a schedule of upcoming appeals, there are those decisions that we've made in the past that you might have an interest in. So please explore that on ilcc.gov.
All right. Thank you, Richard Haymaker, for hosting today. And thank you, Jackie, for answering any questions. We thank you all for joining us. Again, if you have any questions, please submit them to the legal inbox that was submitted via the chat. You can also watch other webinars on our YouTube channel. I'm going to put that link in the chat as well. If you have any additional questions, reach out to us anytime. Thank you for joining us, and you all have a wonderful day.